Good morning, everyone, and welcome. Just so we know where we are, this is a webinar on legal fundamentals for private, owner-managed, and family businesses. My name is Nick Torchetti. I'm going to act as your moderator this morning. Just so everyone knows, I'm a partner at Airden Burles's Corporate Commercial Group, and I'm co-chair of the Private Business Services team. The Private Business Services team is a multidisciplinary group of Airden Burles lawyers who focus on the needs of private businesses, from incorporation, organization, and governance to dealing with succession planning, tax matters, and everyday employment, real estate, banking, and commercial agreement matters. Today we're going to discuss some legal fundamentals for private businesses. Some of you may be disappointed to know that we are not getting into income tax-related issues. That area we think is big enough that we're planning a further webinar focused solely on income tax issues for private businesses. I want to introduce now our speakers in order of appearance. First off, Cecilia Moffat is a partner in our corporate commercial group. She's co-chair of the Private Businesses Services team. She has spent more than 30 years advising private companies private company clients in corporate commercial matters, including governance, agreements, and private M&A. Rachel Blumenfeld is a partner in the Estates and Trust Group and specializes in personal tax planning and related business succession matters. She is a director and national secretary of STEP, which is the Society of Trust and Estate Practitioners, and a winner of STEP Canada's Volunteer of the Year Award. Congrats. Lorenzo Lisi is a partner and leader of the firm's Workplace Law Group. He acts substantially for employers in defending employee claims or dealing with unionized workplace. Lorenzo also advises management in respect of employment issues upon the sale or purchase of a business. And you may have heard Lorenzo yell at you through the radio. He's a very regular speaker. Finally, Paige Backman. Paige is a partner in the Corporate Commercial Group and is, in fact, the practice group leader. She also chairs the firm's Privacy and Data Security Group. Paige also has expertise in technology-related matters and is a frequent speaker on technology and compliance with privacy laws and cybersecurity. So with those introductions out of the way, we're going to get started right away on some shareholder agreement matters. Cease Moffat, the first question I'm going to throw to you, and hopefully you can follow along with the slides, which will give us some guidelines as to where we are in the program. Cease, first of all, you and I have done a lot of shareholders agreements, from one-page unanimous shareholder declarations to 200-page monsters that are very complex that nobody wants to ever look at again. So why is a shareholders agreement important?
Thank you, Nick, and first of all, good morning to everybody. I would typically recommend that all shareholders of a private corporation enter into a shareholders agreement, because without one, your relationship is going to be governed by the applicable corporate legislation. And in most circumstances, that just won't be desirable. It's far too limiting, and it's not protective or reflective of the respective interests of the shareholders in the corporation. So a shareholders agreement, as Nick said, whether it's 100 pages long or a shareholder declaration, forces the shareholders to think through their actual relationship and what the expectations of that relationship would be, and including with respect to the corporation's management and operations, and to actually change it from what might otherwise be prescribed by the applicable governing legislation. Shareholders' agreements actually end up minimizing disputes among shareholders because they provide a roadmap for the shareholders. And they also, in the case of, let's say, a minority shareholder, they're going to provide some liquidity provisions and some contractual rights that the statute otherwise wouldn't have given them. When drafting a shareholders agreement and getting into the complexities of thinking of what goes into it, I always remind clients that notwithstanding they end up with the shareholders agreement, they can still agree to act outside the confines and the terms of the agreement. So it's really the fallback position, especially if the relationship goes sour. A shareholders agreement will serve different purposes depending on the interests of the shareholders. So I'm going to touch on just three. In particular, let's say you've got two founding shareholders or entrepreneurs, and you've got a 50-50 relationship. Obviously, what's going to be in that agreement will be quite different from a couple of other scenarios I touch on. And there'll be less on governance because you would expect that most decisions would be 50-50. They'd have to be unanimous. But the salient provisions will be dealing with deadlocks. What if that relationship falls apart, which it can, and I've seen it fall apart? How do they exit? How do they get out of that relationship? How do they buy the shares from each other? So that's where we get into the buy-sell shotguns, which are pretty straightforward to draft, but there's nuances to those. The other situation where if you're a founder and you decide that you want to start bringing in employees into your corporation as shareholders, you do it to incentivize them, you want to make sure that you have a mechanism to buy those shares back if they cease to be employees. The most complex agreements that we find, and I think Nick would agree, are the shareholders' agreements involving family members and successive family members. Those take a lot of discussion. They're very sensitive. I couldn't even touch on some of the complexities in this seminar, but it could probably just be a separate discussion. But anyway, that, Nick, I hope, gives you an idea of why I would recommend a shareholders' agreement to.
And certainly, thanks, Issa, I certainly agree with you in terms of the complexity of the issues that you can get into. But, you know, we've seen, notwithstanding the difference in shareholders' agreements from the one-pager to the 100 or 200-pager, sometimes we see fairly standard structures to shareholders' agreements. They look a certain way with, you know, certain recitals up front and certain information with respect to provisions for control and dealing with shares, et cetera. But what would you typically recommend be included in a shareholders' agreement?
So in answer to that question, you referred to the word standard, and I would say there really isn't any such thing as a standard agreement. There's no boilerplate, you know, cookie cutter off the shelf. Granted, the themes, the concepts, there's many similar ones, but how you combine them in a shareholders agreement is what takes a lot of work with the client. And it's all based upon the differing interests of the shareholders in the corporation. I'll just touch on a few very quick points. Obviously, of importance is the parties to the agreement, and we always want the corporation to be a party, and that's to ensure that there's privity of contract. If the corporation is obligated to purchase shares for cancellation, we want to make sure that it is subject to a contractual obligation to do that. You'll see a bulk of the agreement, other than maybe the 50-50 situation, where governance issues are addressed. And remember that under the governing legislation, the OBCA, the CBSA, board composition is basically determined by a simple majority vote of the shareholders. But again, governance can be dictated by the shareholders' agreement such that the directors, they can decide the number, and certain shareholders can have nominees on the board. So all of that can be altered so that the respective interests and rights of the shareholders are addressed in the governance provisions. Also, director decisions, shareholder decisions, we often spend time looking at, are there a list of shareholder decisions or just decisions, period, even respecting the operations that get lifted to a higher level and require the approval of a particular shareholder or even unanimous decision of the shareholders. A lot of discussion around that, and that's all factual based. Every agreement will have transfer restrictions, but then we may include permitted transfers, and that's typically to allow for tax planning. Again, we won't get into that in this discussion, but it may well be that shares will be transferred from family members, et cetera. You'll see on one of my slides, we talk about exit provisions. That's a whole discussion, but again, I will say if you're a majority shareholder, it may well be you want the ability to sell the corp, and we include things like piggybacks and bring-alongs so that the piggyback is more to protect the minority shareholders so that if the founder or the majority sells, they don't find that they're stuck with a partner that they didn't want. Bring-alongs obviously enable the majority shareholder to bring all of the minority along. So obviously, again, you can see the differing interests that are covered off. Buy-sells I touched on a moment ago with the 50-50 situation. Puts and calls, those are usually incorporated when we're dealing with buyouts of employees, and even an employee, if they're terminated without cause, they actually want to cash out, so they may well have a put back to the corp. The other liquidity provisions, obviously dealing with the death of a shareholder, incredibly complicated tax provisions to work in through dealing with those, and life insurance, again, wouldn't be able to get into the detail of that on this seminar. Disability likewise, and as I said, termination of employment. all of these, the other thing that usually has to be covered, and there's a lot more that can go in, is valuation. And I haven't touched on that in the slide, but that can be a discussion in and to itself. How do you value the shares if they're being bought out? Is it formula-based based on EBITDA? Is it a Schedule A that the shareholders agree upon each year? I highly do not recommend that because the shareholders never do it. Never do it.
I've never seen them sign off on what the annual valuation should be.
Right. Or is it FMV and you have to go and retain a chartered business valuator? So again, lots of different issues that come up, and again, no standard agreement.
Right. Agreed completely. And just to wrap that part of it up, you've given us some issues to keep in mind when drafting as shareholders. Can you just expand on those a little bit?
Yeah, Nick, there are a number of issues that do come to mind, but I thought I'd just highlight 4 in particular. One is, do you want your shareholders agreement to be a unanimous shareholders agreement as defined by Section 108 of the OBCA or 146 of the CBCA? So that's an Ontario or a federal corporation. And what a unanimous shareholders agreement does, as some of you may well know, is it restricts in whole or in part the power of the directors to manage or supervise the management of the business and affairs of the corp. And directors typically, they have a fiduciary relationship to the corp. They have to act in its best interest, and that they can't fetter their discretion. However, the shareholders can take some of those decision rights away from them, and they can. The one benefit, and one of the reasons we use a USA is that in actual fact, any transferee of shares, if it's a unanimous shareholders agreement, is actually bound by that shareholders agreement, even if they didn't sign it. So we often use that in succession planning to ensure that, again, when shares come out of a family trust to a beneficiary, they're actually bound by it. A quick one I want to touch on is Canadian-controlled private corporation. Always be wary if you've got a 50-50 situation, 2 50% shareholders, but one is a non-resident. Typically, if it's 50-50 and the other is a resident, it's going to be a CCPC, and that's obviously advantageous for tax purposes. But you want to look carefully at your shareholders agreement and make sure that you don't put anything in it that will result in that non-resident having control. I often go back to my tax group and say, please take a look at this. Have I done anything you don't like? CRAs publish bulletins on it, but be wary of that because you may find that unknowingly in your shareholders agreement you've actually changed your corp and it's no longer a CCPC. Very quickly as well, inter vivos trusts. In some of the family shareholders agreements, we'll often see that we have a family trust with beneficiaries as a shareholder. Just always be mindful, and this will impact on your drafting, that the inter vivos trust, they have a 21-year deemed disposition date or rule. Rachel can speak more to that, but essentially, being the corporate lawyer, what happens is if you don't distribute the shares out to the shareholders or the beneficiaries, rather, of that trust, there's a deemed disposition, there'll be capital gains to pay. So typically the shares are distributed out, but those beneficiaries now become shareholders, and you want to make sure that your shareholders agreement has addressed and covered off to cover that next generation of family members. And then finally, as I sort of close on this question, I would say always make sure that you work with your estates group.
Thanks for that.
Nice plug, right, Rachel? Don't draft your agreement in a vacuum or in isolation because you want it to be consistent with what's going into the wills. You don't want to create a conflict, and you need to work together with the estates.
And Cease, thanks very much for that segue. That makes a lot of sense. Yes, because I would say, Rachel, our corporate group and the estates or wills planning group, years ago we might have talked to each other about doing a will. Can you do this will for a client or something like that? What I've found the past 10, 15 years is that we work so much together because it's beyond just doing a will. It's looking at the shareholders agreement, look at the whole planning aspect of it, business succession planning, estate planning, will planning, all of that. So with all that planning that needs to be done by owners of businesses, where should they start?
So I want to pick up on the second last point that Cease made when she talked about trusts that hold that hold shares of a family business, and it's generally after there's been a freeze and a reorganization. So now what you have is the founders, whether it's two siblings or one sibling or one person, and then owning the value at a certain point, and then the children are entitled to be beneficiaries under a trust. And what I've found in probably the last 5 years or so, I've been doing a lot more planning around the 21st anniversary of these trusts and what happens at that point. And I think that that's a really good catalyst for the discussion around succession planning. That's where it really starts, because you've now got people who have been working in a business, building up a business for 30 years. So they, 10, 20 years into it, they did a freeze, and now they're in their 70s or 80s, and their kids are in their 50s. And you're about to get to that point where you need to deal with that trust and to transfer out shares to the children, who are no longer really children necessarily, and really I think that's a good starting point for families and for businesses to start talking about what's the structure of the ownership going to look like going forward. And some of the things to keep in mind when they're doing that, and I've got a couple of slides on this, but I don't think we're going to really go through the slides.
We'd be here all day.
Yeah, exactly. But some of the things for them to be thinking about at that point is going forward, what's going to happen on the death of the founders, and that's certainly something that the shareholders agreements will look at. But it may be a point in time where you need to revisit the shareholders agreement. And as you had said, Cease, to pick up to make sure that what's in the wills are in sync with what's in the agreement. So your agreement, and there have been a number of cases over the years that have dealt with this, where an agreement will say no shares cannot go to spouses. It can only go to the descendant. They can only be left to descendants. Well, what happens when somebody leaves all of his shares to his wife or to a trust for his wife? First of all, you have a tax issue, because you've now not been able to roll those shares over to the spouse, but you've got a mismatch between what the agreement says and what the wills say, and in those cases, the agreements will trump what's in the will. So you have to be very careful and that's why Nick, we need to talk about you've done an agreement and I'm doing the will. I need to see the agreement, and sometimes I get a bit of pushback sometimes from clients. Well, you don't really have to look at our agreement; it's so long. But I want to make sure that it's all coordinated. The other point I think that you made also in terms of will planning is, and this is sort of an easy one to deal with. For us in the estates group, is to make sure that we do some probate planning around using what we call multiple wills. So you had mentioned in your slides primary and secondary wills, and really the point of that is to ensure that you're not, at least in Ontario, you're not paying probate fees on assets that don't require probate in order to be dealt with. And I know we've had a session on that about a year or so ago, and we can certainly talk about that in another session.
So that's a standard approach. We look at that. Are there other, I'll call them succession and estate planning approaches that we should look at? I mean, you talk, and I think you're right, you talk in terms of the business succession process. It's a process that should start with the family taking the time to get buy-in, so everybody's on the same page to say this is what we think will happen with the family, with the business in the next number of years, and then you put the appropriate agreements in place to implement that, whether it is an estate freeze that brings a family trust into play that you make sure is aligned with the shareholders agreement, and you think the 21 years out and how that's going to play out. But I know we've had some questions as well, Rachel, about some of the issues around that are, how do I deal with, potential marital breakdown in my kids? Because my kids may be the beneficiaries of the trust, and at some point my kids are going to own some or all of this business. How do you protect those assets from marital breakdown?
That's probably one of the toughest questions to deal with, because there's really a lot of uncertainty around family law, and the family law area. At least, I mean, I'm an estates lawyer. I don't do family law, but we see it a lot, and we deal with marriage contracts and prenuptial agreements.
So is that the best solution in terms of a prenuptial, or is there other stuff?
So it really depends, and it first of all depends on what province you're in. And I'm assuming most of the people listening in are in Ontario, and Ontario today still differentiates between married spouses and common law spouses in on certain issues. So with respect to division of property, which is really what you're concerned about here, because you likely don't want shares going to a separated spouse of a child. In Ontario, under the Family Law Act, if someone receives either as a gift or as an inheritance shares after, or an interest in a trust that holds the shares after they're married, then to a great extent those shares are going to be protected under the Family Law Act from a division of property on a subsequent either death or divorce. So often we'll talk to clients about doing some planning after their kids have married. So if we're going to be doing a freeze around the time when the kids are in their, let's say in their mid-20s, maybe you suggest that they wait until the child is married, and then the law itself, the legislation, will provide some protection there. When that, otherwise you do want to be looking at getting into a prenup agreement, and there's a couple of really key elements to make sure that that's enforceable. So you want to make sure that everybody's getting proper independent legal advice, that there's full disclosure, those kinds of things. So the agreements, I think, are certainly very helpful and very important, but it's sometimes, first of all, hard to get your kids to agree to go to do one.
Right, we've seen that.
We've seen that, and there are agreements that get overturned all the time, and really the key is when it's being negotiated, you want it to be truly negotiated between the two parties, and you want them to you want it to be fair.
Right.
And I think then it's easier to have it enforced.
Right. So I know it's a pretty complex area. We have lots of discussions, lots of planning around what the estate plan looks like. Part of the estate plan is, of course, as we've discussed, is the will, the primary and secondary will, hopefully, that is tax effective, or at least probate effective. Let's talk a little bit about the will, and you've talked about the importance of choosing an executor or executors. I mean, I've seen situations where business owners want to have a whole panel of executors. They want to have 5 people kind of continue to run the business. Some are, advisors, some are good friends, some are family members. What's your recommendation?
Yeah, so the choice of executor really is critical here. It's where there's a family business in place, because those executors become the shareholders, and as shareholders, they're bound by an agreement, and they will often vote themselves in as directors. So you want to ensure that they're people who are able to manage the business, or if they're not, that they're open to bringing in proper management to help them. I tend to, in these kinds of situations, I tend to suggest probably 3 executors, but so not getting into the board of 5, but
right.
3 is probably a good number, especially if you have a spouse going on, where there's going to perhaps be a trust for the shares for the spouse. One of the things you really have to be careful of and be cognizant of is the situation where that person who's the executor has a lot of different hats. So they're the executor, so they have a fiduciary duty to the beneficiaries. They may be a beneficiary themselves. They may be the spouse who's a beneficiary of a trust. They often will become directors, and they also may be shareholders in their own right. So if you're choosing a sibling that you've been in business with, they'll have their own interests, and you have to, I think, deal with the fact that there could be a conflict of interest in that person acting as an executor, and you want to deal with that either by forgiving it in the will, or by saying that in certain decisions this person should recuse himself. But that is an area where there's been a number of cases over the years. And one of the things that you really need to deal with, I think, in the will is to ensure where there's a surviving spouse, to ensure that there's going to be an ability for that spouse to get income, that there's a requirement to push the income up from the company into the spousal trust to ensure that there's dividends flowing out to that. So, going back to the shareholders agreement, you may want to be looking at a dividend policy being embedded in that agreement.
I think you're right, and that's where the alignment comes back in. So it's not only with respect to the transfer of shares, it's also with respect to a dividend policy with respect to funding, the surviving spouse. Suffice it to say, it's a complex area, and that's why you need to plan. You can't just, implement, something that hasn't been planned out, where you haven't thought about the whole business succession, the estate planning, and coordinating it with the will. So thanks for that, Rachel. I'm going to switch over now to something a little different, and that's with respect to employment matters. I indicated Lorenzo Lisi chairs our workplace group. Lorenzo, whether, for a lot of private businesses, and I see as a generalist, I get calls all the time. A lot of those calls are about employment matters. What do I do here? What do I do there? How do I sever this relationship? But and I know you do a lot of that. I know I turn to you for a lot of that. But how? Let's look at the beginning. Whether it's a family member, or a senior executive, or anyone that's being hired by a private business, how should an employment relationship be structured? What's the way to do that correctly?
Thanks, Nick. So I'm going to pick up on the marriage analogy. Having been married for 30 years, I'm very self-aware. It's the only litigation I can't afford, by the way. So I'm going to use that in the employment context, because employment lawyers, particularly management side, look from the divorce backwards rather than the marriage forwards. So we look at when there's a divorce, what are the rights of the parties? What do they get? Have they been contracted? So if there is a specific employment agreement, the law in Canada allows us to create an employment agreement which guarantees minimum statutory amounts but can contract out of common law amounts, which is judge-made law when people sue their employers when they get fired. So we want to, and particularly when you're talking about private businesses and in particular family businesses, nobody thinks about what's going to happen if Junior ends up taking this position and we have to fire him. That's complicated in many family businesses by the fact that you often have aunts and uncles who are involved in the businesses, fathers and grandfathers who have their own allegiances amongst the kids and grandkids, and that has to be worked out. So on the prenup, which is the employment agreement, if I can stay with that analogy, on the prenup, you want to set out what the rights are in the event that there is a termination. And not only just a termination, that's just one of the terms of an employment agreement. We want to define in that contract, and it's hard sometimes to get to turn people's mind to signing a contract. And let me just be very clear. You can always give more. This is to protect yourself in the event that something down the road goes wrong. Just in case somebody starts performing in a manner or you need to exit them from the business. So we get an employment agreement, and the slide that you see there really does talk about some of the issues that you have to think about. These aren't the only issues, by the way, and we've heard some of them today. They have to be coordinated with rights under shareholder agreements if there's shares that have been issued. But effectively, what we want to do is set a framework for what happens in this relationship. What are the duties? What are the scope of duties? What do you get paid? Are there bonus structures? What happens on termination? Right? Is there a set out severance amount, or are you only going to get what's minimum under the law? How do we deal with situations like post-employment restrictions? Do you need them out of the business? So these are all the things that you need to think about. And what I always tell clients in these situations, particularly in family-run businesses, and I'll tell you, we often get brought into these things when there's already litigation or it's already heated up. And think about your siblings arguing, multiply that by 100 when there's money involved, right? And that's what you get. And I'm sure Rachel can speak to that when they're inheritance matters. So really what we want to do is just set them out. So get a sheet of paper and put down the things that you think are important. If there are shares, if there's an inheritance, all those things should be worked in and coordinated in the employment agreement so that we have certainty. Again, you can do more, but we want to make sure that there's a base which governs the employment relationship in the event that things happen, whether it's a resignation, a termination, with or without cause. We want to know with certainty what can happen. And I will tell you, that will lower the stress level, because family members lawyer up right away. We'll talk about that in a bit. They lawyer up right away. At least, even a really bad lawyer will have to look at an employment agreement if it's validly executed and say, they've got some rights, you're going to have to fight against those rights. So really, it's the prenuptial agreement. It's setting out the terms and dealing with the divorce.
So let's get to the divorce.
Let's do that.
Okay, so and I'm not sure what termination for cause is anymore.
I've been doing this for 30 years, and I'm not either.
Good. Okay. I just refuse to go there, because it seems that anytime a client of mine tells me what he or she thinks might be cause, it ends up being not even close. So let's go to termination without cause. And what's the way that you recommend that take place?
So there's lots of ways an employment relationship can terminate, including a resignation. But even on a resignation, there may be rights and compensation which are due and owing. So the employment agreement that we talked about should set all those things out, what the rights are. But particularly in family situations and owner-managed businesses where people have been brought along, you might have friends of the business, there might be lots of people who have been along for years who are not adding a lot of value anymore, may have shareholder rights. You really do have to if you're looking to the agreement that sets it out, we've got the blueprint, right? That's the playbook. But where there isn't, and there might be issues of equity, where there might be post-termination restrictions, one of the big things that you really have to address is if we're not terminating for cause and there's nothing in the employment agreement, we go to common law. What's the period of reasonable notice that the courts would award? Do we want to provide some of that as working notice, or is the relationship so ruptured that we can't allow that to occur? Do you want them out of the business right away? Is there going to be a scenario where we can sit down and get all of this done? Part of that is to take a look before and do this before. Do it before you're contemplating having a discussion with the employee. Sit down and find out where you want to be. If you don't know where you want to be, you're going to go on a lot of different paths. Where do you want to be? How long do you want them to be in the business? How do you want to address this? If there's going to be a severance package, structure it. Is it a lump sum? Is it a salary continuance with a clawback if they find another job? If it's a family member, do we necessarily want to insist on that? Do we want to be a bit more generous? Do we want to be a little bit more mediative, if I can put it that way? So, in many cases, what I'm suggesting, and particularly in family-run businesses, let's calm this down. Let's take the emotion out of it, and let's, if there are already camps that have formed, right? Do we want to actually get engaged in mediation? But the decision to terminate on a without cause basis needs to follow a structured package. Either we go to the employment agreement, what it says, and produce that, or we create a structured package which can include all of those things that we talked about. That package should talk about what happens after they leave. Post-termination restrictions. Are we worried about them starting another business and competing? Are we worried about them soliciting? Are we worried about their conduct, disparagement, what they're going to say? All of those things have to be managed. That's why you need your friendly employment lawyer to give you that advice.
So, and here's where I think it gets difficult. You touched on it a bit in terms of talking about the shareholders agreement. So you have a family member who has been terminated without cause. That family member may also be a part owner of the business. The shareholders agreement may or may not. So now you have, you're dealing with someone who has been wearing two hats.
Yes.
They've been an employee and they've been a part owner. How does that separation work, and how do you deal with that?
Well, so first of all, you go to guys like you and you take a look at the shareholders agreement and you look at any employment agreement or what the terms of their employment have been. I can tell you there are sometimes, particularly when there's an employee with shareholder rights, there are oppression remedies which are brought as a result of a termination which you've got to deal with. Even on a constructive dismissal, there's lots of law on that. But really the way you deal with it is by first assessing where your risks and liabilities are, treating them fairly under the shareholders agreement and complying and abiding by the shareholders agreement. I tend to separate the termination part of it from the equity part of it, because oftentimes those obligations are set out, and if they're not, you have to actually figure out a way on how to deal with that fairly, because otherwise you might get litigation automatically. So I think you parse it, Nick. We're going to look at this from a termination perspective, from an employment law perspective. What would they get if they sue if we don't have an employment agreement? And then deal with that in the totality of what the package might be. And I like putting it together. saying this is your entire package. This is what it's going to look like. Go out and get legal advice, and let's see if we can get this resolved. All right? If it has to go to litigation, very few family issues get to litigation. Although if you look at the McCains out in the East Coast, I think that lasted about 35 years. But really, that kind of tells you why it's important to structure it ahead of time, but also why it's important to deal with it objectively if you can, and deal with it sometimes with a third-party mediator if that assists.
And that's where it gets important, I guess, as part of managing the fallout, which you've indicated in your slide in terms of effective communication. Do you want to spend a minute on that?
Sure. Part of the big problem is that both family and other employees in the business have already set up camps. They're one side or the other. They can be with either the family member or the other individual who's been terminated, or on the side of the corporation. And you find that is not only a split legally, but it's inefficient, it's unproductive, and you start to lose the value of good employee relations when you do it that way. So a lot of what we recommend at the front end is do the pre-planning, understand where your risks and liabilities are, have a communications plan when the termination comes into effect, right? And that might include, for example, as with any good termination strategy, making sure that the employee can no longer openly have access to your systems or communicate with employees. That's a very simple thing to do. Sounds awful that you cut them off from their email and their access, but if they're no longer employees, that's what you do. They can still get back at you, but we want to manage the communication. Sometimes in bigger businesses that are family-owned, we may want to get some PR advice, because that might get out into the market, it might get out into the general public. We may want to get that done. But most importantly, you want to understand on how you deal with your employees moving forward, or you're going to have a very inefficient workplace for a long time. Family, in particular family law litigation, really does take up a lot of time and a huge amount of energy, and it takes the business off its axis a bit. So use that as an opportunity to manage the fallout positively with employees. Sometimes you're going to have to tell it like it is. This was no longer a working relationship. We had to stop it. We're moving forward. Other times it might be a more communicative process.
Great, thanks, Lorenzo. And I know we as corporate lawyers rely on your group quite a bit, not only for dealing with employment and termination, but also on the transfer of employees in a merger and acquisition scenario. We come to you a lot with respect to determining successor employer obligations and employee rights. So thanks for that, and hopefully in some future discussion we'll talk about that as well. I want to move now to Paige Backman, and I said earlier with respect to Rachel's work in estate and wills planning, we've worked more and more with that group over the years. And with respect to the kind of work that Paige is doing in data and privacy, 10 years ago, I don't think anybody knew what that was. And
very few of us.
Very few of us. And although a lot of it applies, there are laws of general application, as they say, we normally, as a society, we think of data and privacy as, issues that apply to breaches of of a bank system or a credit card issuer, or somebody gets hacked. Mm-hmm. So in particular for private businesses, I mean, that's what we hear about, and that's where you hear about liability arising. But in terms of, private businesses, smaller, but not necessarily all small family businesses, what kind of data and privacy issues do they face?
Well, thanks, Nick, and thanks everyone for joining us. So let's just start with a few premises. I'd love to bring in the analogy of divorce and prenups, but I just can't in my area. So I'll just say this is more about protecting your family. You're right, Nick, in that what we see is more of the sexy stuff on movies and the news with state orchestrated attacks, and while those happen, those are certainly not the most prevalent types. I'll get calls probably once a week, usually Friday afternoon, where it's a smaller business or a family-owned business that have just, they're subject to a ransomware. Ransomware is sort of the new pickpocket. And so what we, in terms of, the approach taken with the wills and estates and labor and shareholders, which is to try to deal with things up front, we try to address things in a similar fashion when we come to data security. If you step back for a minute, every business in this day and age has information as a fundamental part of their business, whether it's just to even operate as a business. And there's the larger data, and then there's subsets that may include personal information. Those are governed and regulated by different areas of the law. Personal information is about individuals, and that's regulated by statute, more or less. And then the larger data or information is generally regulated at contract levels. So when we have data breaches, what we're talking about is sort of an unauthorized access, use, or disclosure or intrusion to data, to some form of data. And when we're responding, and I'll tell you one of we think of the more I just call them sexy, but like the more what we see in the news are again these very sophisticated intrusion attacks. The greatest risk to any business stems from the employees and human error that happens within a business. And a lot of some of the issues that I'll see relatively regularly is that an email will be sent by an employee to the wrong person. And that's usually, sometimes it's done by what we call phishing. And an email will come in to an employee. It looks like it's coming from their boss or supervisor or someone from IT, and they're asking for a password or they're asking for a file. And they just send it because that's just human behavior. We call it sort of social engineering. Essentially, it's just how humans react. We will respond when asked to do something, particularly when it's from someone in a position of authority. That is probably one of the most prevalent types of data security breaches that we see, which is someone just reacting to a request from someone that they trust, whether it's providing a password, clicking on a link, or providing a file. So when we look at how to prevent this, depending on your organization structure, I always say that the best bang for your buck, you have to have the basic virus protection, but the best bang for your buck is training your employees, and not just training them once and checking a box. This is training your employees practically every about 6 months. But then the most important part is auditing or checking to make sure that those employees, and I'll say employees, but I'm also saying any third party who has access to your network, understands and will react accordingly. So what we'll do, or what we suggest, is you do a training session with how to manage security. And I'm talking about security for all data, including subsets of personal information. And then about 2 to 3 months after your training, not immediately because everybody's on heightened awareness, but let's say 8 weeks to 12 weeks after the training, you do some very simple tests, which is to have call someone, there are organizations that will help you with this. Have them call in, see if they can get an employee to share a password. Send an email to see if someone will click on a link. Leave flash drives around your offices to see if someone's going to pick them up and install them into your computer. Honestly, it's an easy way for someone to introduce a virus, which is just to leave a flash drive. It could be in the bathroom or it could be in your lobby or whatever, and they think it's great, and they pick it up and they put it in your system, and they've just introduced a virus to your system. And the viruses can do a number of things. And one thing to keep in mind is that there's usually a lag time of about 6 months from when a virus is introduced to your system and when it becomes apparent. So within that 6-month time, it can do a lot of damage, and it usually goes undetected. Or usually it can be operationalized remotely. And that's where we get things like ransomware. And ransomware is simply them introducing a malware into your system, and then it shuts your system. It encrypts it. You can't do anything with it, and it'll shut your business down unless you've got a backup set of data and systems that you can work with. And then they'll say, great, I'm going to send you the encryption key if you pay me $10,000. It's a phenomenal, highly illegal way to do business, and it's very lucrative. There's no capital investment. They can do it from their chairs in whatever foreign country or domestic that they wish. And it works because you pay them the money. Generally, I want to disclaim, if you pay them the money, they'll give you the keys and you can go on.
Are you telling us then that that happens a lot and it doesn't get reported and publicized? Because
there's very so if this yes it happens. It's becoming more frequent, and the dollar value has gone up. It used to be around $1,000, $1,500. Now we're looking at about $10,000. It's a small enough amount that people would be prepared to pay. Bless the police, they just don't have the capability to investigate all of this. So, you report it to the police, but you will need to ensure that you have the capabilities to have backup systems that you can run, which have been uncompromised by the virus that has been introduced. So in terms of and let's just stick. We've talked a little bit about ransomware, but let's talk about just a general disclosure of personal information, privacy laws. So privacy laws relate to the regulation of personal information about individuals, information that can identify an individual. We have laws and common law, both statute and common law, which will impose obligations on organizations to regulate and to manage and to secure the data. If you breach that, if you go offside, you can be subject to investigations at both the federal and provincial level, depending on where you are, but also you can be subject to lawsuit. And it has become a cottage industry for class action lawyers to bring suits regarding data breaches and privacy breaches. And I always feel bad for the companies when they call and something like this has happened, because it's usually a very innocuous circumstance that has led to the unauthorized disclosure of the information. We are working with one right now, which is just absolutely bizarre. It deals with people who we're defending a healthcare. We're defending. It's a healthcare-involved class action, and it deals with people within a healthcare organization just or looking at a file through no malice. In fact, they would know that the person, and they were just checking up on them just to see how they were doing. So possibly across the line, but there was no damage, there was no disclosure, and yet the claim that was brought was a multi-million-dollar claim. So you're getting this cottage industry of absurd claims that don't deal with true harm that's being done. So what we always say, to go back to the prenup analogy, is try and deal with these things initially by having strong policies. But again, I can't emphasize enough, training your employees, training any contractor that has access to your system, and following up to make sure that they actually do what your policies provide and what your training has instructed them to do. Because policies without actually checking them mean it's a waste of time and a waste of money for everybody.
Paige, just before we get into some questions, those issues are obviously pretty important, but sometimes you don't think about the fact that you're contracting with some supplier, for example, an IT services provider of some kind, even payroll provider. So you're entering into service contracts with people who have access to some aspect of your system. You touched a little bit about on that, and how do you deal with that? How do you protect yourself from making sure your customer information and your financial information remains intact?
It's a great question, and really something we need to focus on, because a lot of people are outsourcing certain functions, certain operations within their businesses. Payroll is a great example. You have to look at those people like they're part of your organization and ensure that they are adhering to the policies and conduct that you're expecting from your own operations. You need to be sure, so you need to do due diligence on any third party that you're working with who may have access to your network or your data. I've had a situation where it was a very large payroll company, and they sent a payroll spreadsheet to the wrong company, and it was simply a matter of email autocorrect. It's one of those simple errors that happens, and it went to the wrong company. But you have 3,000. You've got now it was a breach of several thousand employees with their social insurance numbers. With their salaries, home benefits, they have their home address. So it was, luckily this one was contained and everybody acted in an ethical manner. But something so easy as that happens. So in your contracts, so you talk about you want to do the due diligence to make sure you're operating with people who have experience in this area. In your contracts, you want to make sure that data protection is front and center. We always say, well, why do you need reps and warranties? Well, you want them for a claim, but ultimately you also want them so that you're ensuring the other party's turning their mind to these issues and and you're comfortable that they can adhere to them. Then you want to make sure that if there is a breach, that one, they indemnify you, and two, they help you with the investigation at their cost. So those are some of the contractual terms you're going to want to ensure are in your contracts, and don't leave them to the end when there's access to data. Those things should be front and center in your negotiations with the third party.
Great. Thanks very much, Paige. With the time we have left, we want to spend a few minutes answering some of the questions. Obviously, we won't be able to answer all of the questions we received, but there's some commonality amongst them, and I want to take a look at them and see if we can provide some quick answers, and perhaps people will be interested in those answers. One of the questions for you, Rachel, is with respect to owners of companies that are U.S. citizens. I take that to be as, kids, for example, or beneficiaries of trust that might be U.S. citizens. We've seen a lot of the children of business owners move to the U.S. for school, end up staying there, and then your planning has to change substantially when that happens. You want to comment on that?
Sure. And I think probably every other file that comes across my desk today has some sort of U.S. connection, whether, again, it's kids who are in the U.S. Very often what will happen where the kids stay in Canada, they end up marrying somebody who's a U.S. citizen, and then all the next generation are U.S. citizens, even though they're living here. And I've seen that a number of times in situations where we're dealing with the wind-up of a trust on a 21st anniversary. So this trust was set up when the kids were in their early 20s. There was a freeze done. And then, 2, 3, 4 years into this, kids get married, and they get married to Americans. And they live here, and they work in the business, but now you have a whole generation. The grandchildren of the founder, who are all beneficiaries of these trusts, are all U.S. citizens. And usually we don't, what I've seen is that was not contemplated in the trust when it was set up. The issue there is really, these are U.S. issues, these are U.S. tax issues that are pretty significant, and they're tax reporting issues in the U.S. You're not necessarily paying tax to the U.S., but you have to be reporting this ownership, generally reporting the ownership, depending on the situation. I think I have two pieces of advice. Is one, don't ignore it. Don't think that, oh, well, nobody's going to know that my kids are U.S. citizens because they don't have a passport. Well, if one of their parents was a U.S. citizen and born in the U.S. and lived there for a number of years, chances are pretty good that that next generation are U.S. citizens. And my next piece of advice is get U.S. advice.
Right.
Bring in a U.S. Somebody who does a lot of that cross-border kind of work in the U.S. on the U.S. side, because you may be looking at doing voluntary disclosure in the U.S. or something like that. But don't ignore it.
Don't ignore it.
Yeah.
Cease, one of the questions is for you. I think you touched upon this, but it's how to protect a minority interest in a private company environment. You touched upon it. If you just want to give us a quick answer on that.
I did touch on it, Nick, and obviously when you're a minority shareholder and you want your interests protected, what you're really looking at is two things. I think, number one, are there certain decisions that as a minority shareholder you might wish to have a say in or have a voice? I will say it can sometimes be an uphill battle, especially if you've been the basis on which you've been brought in as a minority shareholder. If you're an employee, you're probably just along for the ride, and the idea is you're going to help grow the business and with a view to at some point cashing out even with the majority shareholder. But that would be one situation, and trying to negotiate, are there certain decisions that you'd like to be part of. The second, of course, as a minority shareholder, I touched on this, if the majority wants to sell, you want to make sure you don't get left behind. So again, we'll draft whether it's right of first refusals in the agreement. Typically, it's very hard to give minority shareholders liquidity other than, again, they need to wait until the majority sells. If they happen to be a family member, likewise, usually family members, the majority wants to be able to force the minority to go along as well. But we would draft such that there's piggyback rights. I mentioned that sort of, we call them piggybacks, bring-alongs. It really just says if the majority sell, and the majority could be any definition in your agreement, that as well, you have to look at the structure. It could be 50%, it could be 75%. There's no magic, but it's based on the facts. They get to go along with that sale. And the flip side, again, would be that the majority shareholder, if they're talking to a third party and they want to sell their company, then they don't want the minority to hold up that sale. So they will have what we call drag-along rights.
So can we just confirm, because one of the other questions was along the lines of what rights to information does a minority shareholder have?
So there's provisions right in the governing legislation in the OBCA, if we're talking to the Ontario audience, or also the CBCA, that set out, it's actually limited informational rights as a shareholder, but every shareholder is entitled to a copy of the financial statements. They're entitled to see directors' registers, shareholders' registers. So there's not a lot of information, but there are certain informational rights that they're entitled to, and that's set out right in the legislation. In particular, the copy of the financial statements. The financial
statements, yes, the annual meeting.
Yeah.
And that answers, I think, another question in part as well, that do the minute books need to keep up to date? As a corporate lawyer, we would say yes all the time. It seems rather silly to do annual resolutions which don't, do a lot of stuff, approve financial statements, elect directors and the like, but it's important to have those always up to date, whether it's for financing purposes when your lawyer needs to give an opinion, whether you get an audit from Revenue Canada for any reason whatsoever. It's important to show that the minute books have been kept up to date, and it's cheap insurance.
And adding to that, Nick, I've actually had this conversation with a client that has a very successful business, growing business. His ultimate goal is to eventually sell it. But at one point I had to have the conversation when I said, well, we need to document, we've got to do the annuals, we've got to keep it up to date, we've got to document the dividends, yada, yada. And I ended up saying, listen, we don't want to be scrambling when you're ready to sell. You have to be sell ready. So as much as you think it's just lawyers saying, hey, we want to do that, no, it's actually to prepare you for that next step. So
Good.
Totally agree.
One other question for you, Rachel. You mentioned shares being given to married children would be protected under family law. Any difference if child is common law?
So that's actually, I'm glad somebody asked that, because I do want to clarify. In Ontario, there are still differences between being married and being common law. Other provinces are sort of moving a bit away from these differences, but this is one of those areas where there's a big difference, where there's the provisions of the Family Law Act dealing with a division of property only apply to legally married spouses. So if and this protection that you would get for a gift for a gift to a child is post legal marriage. So there still are going to be those kinds of differences, and you do have to be careful with that, because I think there's really an assumption now that a common law marriage is the same and there are estates rights that are different. There are these kinds of family law difference in family law. I mean, there still are ways that if a court sees something that is not fair on a family law side, that where there's somebody inherited a business after marriage, and then that's what the family, the spouse, the kids all worked in it, and that's where their income is from. A court may look at that on an equitable basis to see and say, no, the spouse is still entitled to something, but under the legislation there still is that differentiation.
Great, thank you. Lorenzo, one quick last question, I think, for you. The question is, do you recommend that owners / shareholders all have an employee agreement or employment agreement in addition to the shareholder agreement?
Absolutely, and I think it's important that you figure out exactly how it's going to work going forward. So that's starting the relationship off properly. If there isn't, and there was a question that dealt with if they don't have employment agreements, can you put them in place? You can. It's important that you get some advice before you do. We still recommend, although there's some case law that supports not having to, giving additional consideration for any new employment contract which has restrictions on termination, post-employment restrictions. You give them some new consideration for signing that, but absolutely we recommend that. Nick?
Great, thank you. I think we're coming to the end of our session. A couple things that I think we can gather from this. One is, even though you might own a small business, any private business, family-owned business, owner-managed business, it's obvious that a number of legal issues can impact your business, and it's important to do planning, to look at what your lay of the land is. I mean, as lawyers, we're not going to advise you to start this the moment you start your business. You want to get your business off the ground. You want to work on your business. You want to make your business successful before you start doing all of this stuff. But it is pretty important, as we said, and I think we heard this from all of the speakers, the more you do up front, the better off you are. So at some point, if you are a business owner, the recommendation is to speak to your legal advisor, speak to your financial advisor, speak to your insurance advisor, whomever that might be. And if you're an advisor to small business, it's important to have these discussions and to really focus on them, because I find that many times as corporate lawyers or as generalists, we tend to say, yep, I can incorporate the company for you. It'll take, half a day, and I can organize the company. It'll take, tomorrow you'll have everything done. And then we don't often take the next step to say, let's talk about your shareholders agreement. Let's talk about employment agreements that need to be put in place. Let's make sure that you are well structured for your success. So in conclusion, I want to thank everyone for registering and for listening in. Apparently there were more than 1,400 of you, which was rather shocking to us, I think.
In many countries.
And not just from the province of Ontario, other provinces, other countries. The Caribbean seems to be a popular spot. I don't know why. And my understanding, I'm told by the people that know, that audio archives will be available in about a week, and we will email them to you. The other thing, I apologize for not getting to all the questions. There were a number of them. If there are some that we can answer quickly, we'll try and get back to you. If not, we hope to have you listen in with us at our next webinar, which, as I indicated earlier, will be with respect to income tax considerations for private businesses, small businesses, family-owned businesses. We think that'll be a popular one as well. Have a great day, everyone. Thank you.
Thank you.